Hi, good afternoon, everyone. This is Rajiv S. Khanna from the law offices of Rajiv S. Khanna, PC, immigration.com. Today is January 25th, 2018. This is our bi-weekly community conference call, which we hold every other Thursday. I will, as usual, get started with the questions. Today, I did not mark any questions as frequently asked questions. My week and day was extremely busy. I didn't get a chance to take a look at the questions either. So we'll do it as we go along. And fortunately, they were able to just close the questions down at 17. That gives me plenty of time to read and respond to any follow-up questions you might have. So the first one is from Madhusudan. Madhusudan says, in the green card labor application, my place of birth is entered wrong. Instead of Madurai, it is entered as Chennai. Well, there is no procedure available to correct a labor certification. So once a labor certification, a perm is processed and approved, there's nothing you can do to correct it, but you should be able to correct it at the I-140 stage. Okay, but if you already done the I-140, you may want to amend the I-140. You cannot amend the labor certification, but you can provide an explanation to the government about what happened, why there was an error, and why indeed Chennai instead of Madurai is your place of birth. So because this is not a major error, I don't think you're going to have a problem. If you had a different country, that might have been a lot more difficult to process. But if it is the same country, same chargeability country, I personally don't think why this should be a major problem. You should be able to resolve this. So don't refile the labor certification. But if your I-140 is approved with the wrong place of birth, go ahead and refile the I-140, get that amended. But do talk with your lawyers. I'm always reluctant to reopen any case without sufficient reason, simply because in the current immigration environment, you never know what the government is going to do the second time around. So just make sure you talk with your lawyers. But I think it makes sense to just redo the I-140. Okay. Star 5. Press star 5 on your phone if you have a follow-up question. Press star 5 on your phone if you have a follow-up question to this. Okay, let's go on to the next one. This one is from Abhishek Verma, who's an Indian passport holder, did undergrad work, graduated in 2006 from USA. Then he was on OPT, then 6 years on H-1B, 2014 to present on CPT, also working full-time. About 10 years of work experience in STEM field. My current company filed for my green card this November in EB2. As my place of birth is in North Africa, Libya, I am thinking my EB status is current. That is correct, because the labor certification the green card chargeability country goes by the birth of the person who's applying or their wife, spouse. So if either you or your spouse were born in a country other than India, even if you have an Indian passport, it is the country of birth that matters. So questions are, when my 9089 comes back, can I file for my I-140 and 485 in premium processing together? The answer is yes. If the dates are still current, definitely. And the dates will be the EB2 dates for the rest of the world. Okay. Will I get my green card almost immediately, or I'll have to spend some extra 6 months on EAD? You probably will have to spend more than that, because remember, they are also going to process an interview for you. These days, because of the Trump administration's smart policies, they are interviewing all employment-based applicants, which could involve several months of waiting in addition to the normal processing time. So I would be surprised if you get your green card before approximately a year, year and a half from the date you file. It's probably going to be in that much time duration. If I file for I-140 and 485, can I leave the country, or do I need to stay in USA? Well, that question is open-ended. I'm not sure what you mean by that. If you mean leave for like an extended period of time, that's a different set of circumstances. If you mean leave just for a few days or a few weeks, if you already have an H-1 visa stamp on your passport, you can travel, but we have seen a pattern where government will deny your advance parole if you travel while it is still pending. It's a crazy thing, but again, I thank Trump for that. They are trying to make simplest things in immigration as complicated as they can. So if you travel without an advance parole, the pending advance parole could be denied. You can travel if you have a visa, an H-1 visa on your passport, but it could lead to a denial of your pending advance parole. That's an alert for everyone who's logged in. Okay, if you travel when an advance parole is pending, they will decline that advance parole. *5, if you have a follow-up question on this, *5, press *5 on your phone. Okay, let's see, we got one. And let's see, looks like Illinois. Yeah, this is from Illinois. Illinois, go ahead. Illinois, go ahead.
Hi, Mr. Rajiv Khanna. This is, I have a question.
Ji.
Basically what happened is I have the Canadian residency
Okay,
in
I'm going to
hand.
stop you. I asked for follow-up questions. Only if you have a question that follows what I just discussed. Today I'll have time. I'll have time to take new questions, but you'll have to wait till the very end. Okay? So just stand by.
Okay, gotcha.
All right.
Thank you.
Okay, sorry guys, I should have made it more clear. So please ask only follow-up questions. At the end, we'll deal with new questions. I'll have time today to do new questions. I have actually told the team to stop the entry of questions on our forums at about 16 or 17, because that usually gives me a little bit of extra time so I can take new questions. But past few months, it has always gone to 24, 25 questions posted. That leaves me no time to deal with new issues. So we'll have time today, don't worry. Let's go back to the next one, which is Narayanan, whose social security number was denied because DHS was unable to verify the immigration documents as evidence of lawful status. Visa and I-94 both got expired 31st December, but visa extension applied in US by my employer. See, there's some misunderstanding here about one second. Some misunderstanding about the difference between visa and status. So when you apply within the United States, you apply for an extension of status. You're not applying for a visa. So I'm assuming what you mean is an extension of status has been applied for. Regular mode on 8th January. And you said, am I illegally staying in the USA? How many days can I stay here? In case my visa gets rejected, what are the next steps? Sir, if you are on the phone, press *5. I need some information from you. Press *5 if you're on the phone. Press *5. Okay, you're not on the phone. Now, I'll try to address your questions kind of hypothetically because I don't really know what your situation is. So, assuming that you are going from F1 to H1, or you were in legal status when your status extension was applied. So, the law is when somebody's extension for any status has been legally applied for, any status, you can continue to stay in the United States, and your legal stay in the United States is called authorized period of stay. So any timely filed extension application or even a transfer application gives you permission to stay in the United States. That's not full status, but it is legal. That is called authorized period of stay. I have actually, I'm pretty sure, a couple of blog entries and several frequently asked questions on that. So if you want to go take a look at our website, immigration.com, look at my blog entries as well as our frequently asked questions, and you can look for something called authorized period of stay. Authorized period of stay, because that's what it is called. In some cases, you can also continue working while your status extension request is pending, depending upon what your particular visa status is. Since I don't have that information, all I can tell you is a timely filed application for extension or transfer gives you the right to stay in the United States while you wait for an outcome on that application. That's the general rule, but that doesn't mean I know your case. If you were here, I would have asked you a couple of questions. Since you're not, just talk to your lawyers and make sure that your application was timely filed and everything else is complied with. I don't see why you cannot stay in the United States. *5, if you have a follow-up question on this, *5. Let's go on to the next one. This one is from Arjun or Arjun G. Arjun G, sorry. Oh, that's what it is. Okay, Arjun G. I received my green card in June 2015. I have a re-entry permit expiring in 2019. My fiance is in India. I've got a B1, B2, and she's got a B1, B2 tourist visa. Questions regarding continuous residency requirement for US citizenship. Okay, let me explain this. I've done this a few times, but let me explain this to you, how this works. In order for you to apply for naturalization, you must have had, and this is if you're not married to a US citizen, if you're just by yourself, a green card holder. Marriage through a US citizen is a little bit different, and citizenship through naturalization takes 3 years instead of 5 years. So let's talk about the normal case where you must have been green card approved for 5 years. In the 5 years immediately preceding the date of the naturalization application, you must have been physically in the United States for 30 months, which is 2.5 years. Okay. On top of that, you must never have abandoned your permanent home in the United States. So if you decided to move to India, you took all luggage and everything out, found a job there, but you were gone only 6 months, that could still lead you to lose your green card if the government wants to take it away. Because leaving USA with an intention not to come back is an abandonment of green card. So you must not have abandoned your green card. That's another requirement. None of your stays outside USA should have been 1 year at one time. If it's less than 1 year, more than 6 months, at any one 12-month duration, you must explain it, why you were gone for that long. Government needs to assess whether you lost your permanent residence. So there are several rules, not just one. And a re-entry permit does not give you an exemption from maintaining those physical presence requirements. N470, which is what you have talked about, also does not give you physical residence, but it prevents interruption of your period of stay in the United States because you were gone too long. Let me explain to you how that works. So if you file an N470, and of course you file a re-entry permit to protect your green card, these are two different things. One protects your citizenship, the other your green card. And then you leave USA for 1 year. If you had no 470, you would have to start your residency period, which is 5 years normally, 4 years if you have applied for re-entry permit, all over again. But if you have an N470, you don't have to apply your 5 years all over again. What you need to do is still have 2.5 years of physical presence out of the last 5 when you apply for your naturalization. And it sounds complicated. It really is not. So once again, green card approved for 5 years, physical presence 2.5 years, none of the visits outside for a year or more in any 12-month period, Any 12-month period, if you're gone more than 6 months, less than a year, you must explain it. These are the general rules. I think that's kind of what you're asking. Who is eligible to file Form N-470? So basically, even people who are working for foreign American-owned companies, foreign branches or subsidiaries. For example, an employee of Amazon India, because Amazon India is owned by Amazon USA, then you can file an N-470 if you're going to go work for Amazon India. Okay. My re-entry permit expired, expires in Feb 2019. Can I apply for extension from India? You cannot apply for re-entry permit extensions from outside the United States. Can you file family-based green card for your wife while you're staying in India? Yes, you can. The only requirement is when she goes for her interview, because you filed an affidavit of support, you must either already be domiciled in the United States or relocating back to the United States. So that's the only requirement, but you can file while you're still in India. I think I covered your questions. If you have any follow-ups, press *5. *5 on your phone, please. Okay. This is Houston. Yes, Houston, go ahead, please.
Rajiv, thanks for your service.
Of course, my pleasure.
Yeah, so based on your responses, I'm sorry, I'm getting some echo. Based on responses, I just want to have a follow-up question. You mentioned about continuous requirement, physical requirement, last 5 years, and last 2.5 years in the US. Based on my scenario, if I go to India and file my re-entry permit to preserve my green card and also file N-470, I work for a US-based company, to preserve my continuous residency status, when I come back when I work in India for the next 2 to 3 years based on my wife's green card approval and come back to US next 2 to 3 years, does it mean I just have to spend remaining 2.5 years to apply for my citizenship?
Right. Because, now, first of all, remember one thing. Because you have filed the N-470, your stay outside the United States, even if it is for more than a year at one time, will not interrupt your green card. It won't give you physical presence, but it won't interrupt your green card. That's how I remember it. So basically what happens is, let's say you already got 2.5 years of stay, and then you leave USA for 3 years. Okay? And you have an N-470 filed. When you come back, in the 5 years, last 5 years, you've got 2.5 years already, or maybe 6 months, 6 months less. So if you spend another 6 months, you can file your green card. So you don't have to redo your physical presence or redo your 5 years of green card, even if it is interrupted by a year, if you have N-470 filed. That's the only advantage. Otherwise, N-470 doesn't give you physical presence.
Okay, so when I file N-470 and if I stay in India, will this time will be added to my count of 5 years?
No.
So far I've already completed 2 parts. Okay.
Let's do it again. Okay. So let's say you leave India today, January 2018. You left. You already have, let's say, 3 years of physical presence. Okay. You had a green card for 3 years. You've lived here for 3 years. You left. Now you stay in India for 3 years. You've got your N-470 approved. You've got your re-entry permit approved. You stay in India for 3 years. Okay. If you did not have N-470, you would have to start your 5 years. Actually, because of the re-entry permit, that gets reduced to 4 years and 1 day. But let's say you've got to start your 5 years all over again. But because you have N-470 pending, approved, you don't have to start the 5 years all over again. You just have to have 2.5 years of physical presence.
It's 2 years because I already have completed 3 years in the US before I left to India.
2.5 years of physical presence out of the last 5 years. So if you are gone for 3 years,
okay, got it.
If you're gone for 3 years, now you only have 2 years of physical presence in the last 5 years.
Yeah, got it.
So then you have to have another 6 months before you can apply. Yeah. That's the way I remember.
So I can file N4.
Yeah, that's the way I remember.
I can file N470.
Yeah, go ahead.
Perfect. Yeah, I totally understand. So I can file N470 in India. I'm planning to go in March to India. Should I file it in the US? Or should I file it?
N470 has some weird rules, and I don't remember all of them.
Okay.
But I'll try to put down the ones that I do remember. Rule number 1.
Okay.
Any time after getting your green card, there must be a 12-month period in which you did not go outside USA for even 1 day.
Okay.
So to qualify for N470, there must be at least 1 year during which you didn't go outside USA for even 1 day.
Okay.
And the second really odd rule is, and this I don't remember for sure, but I think you have to be in USA when you apply N470, but you can apply for N470 any time within 1 year of leaving. Okay. So if you left USA in January of 2018, you have like till January of 2019 to come back and file N470. I do not believe you can file N470 from outside the USA. I could be wrong. This is because there are so many rules.
Okay.
We always have to double check these things. But yeah, that's kind of the parameters you're dealing with. Okay.
Rajiv, you have the same example. So if I leave in 2018 and if I file in 2019, the rule number 1, I should not be away from the US for more than a day for last more than a year, right? So that rule breaks.
Under N470, that is not a problem. Under re-entry permit, that is not a problem for your green card. So if you had N470 and 131 re-entry permit approved, you have no issues.
Okay. So perfect. I got it. So the rule number 1 again is I should not be away from the US at least for last year before I fall from the day.
Listen to the recording of this call. Okay. Listen to the recording of this call because I have repeated the rules several times. And if it's still not clear, come back in 2 weeks. We'll talk again. Okay.
And one last question on re-entry permit. So, like what you said, I have to be in the US while filing, and also, of course, I have to be in the US for biometric. I get it. So, so that's something new. I thought I have to only come for the biometric. I can mail it from India. So, thank you.
One quick piece of information. I actually have a very lengthy article on both N470 and 131 on my blog. Go take a look at it. I have explained the law in great detail there. Okay.
Blog. Okay, perfect. I'll blog on N70. Okay. Finally, on the re-entry permit, the last question, sir. So re-entry permit, right? So when I go back to India, I won't have a US address, right? So when I come back to US to mail the application.
Hang on. Re-entry permit can be sent to a US address. It can be sent to your lawyers, or it can be sent to a consulate in India you choose.
Got it. I see that option. In the but while mailing the re-entry permit, right? Because my re-entry permit expires in February 2019, I'll be coming before that to the US to mail the application.
Let me caution you. I cannot help you fill forms. If you have any specific questions, because if I help you fill forms, then I have to sign those forms. Okay. You may want to contact the customer service. Got it. Yeah. Okay. I gotta go on.
Sure. Okay, perfect. Okay, perfect. Thank you.
Bye.
Thank you.
Yeah, it's pretty complicated. This whole thing is so messed up because really N470 don't have to be that complicated, but they have made them extremely, extremely difficult to understand. Okay, so that was Vijay. Now let's go on to the next question, which is Abhishek Khare, about visa extension and upcoming amendment. My current visa and I-94 expired July 2017. Extension was filed 5th July, so timely filed extension. Received an RFE on 14th September, client letter, expert-based letter, organization structure. They received the response on November 15th. Still waiting for the decision. Current project is getting over 31st Jan. I want to know if my previous petition does not get approved prior to submitting new amendment, will that cause any issues? Well, the way this works is, if you have a previously filed extension request pending and you have to either file another extension or an amendment, by the time the second application is decided, if the first application is not approved, government will probably ask you to go get a visa stamping from outside the USA. So if on the date your second application is decided, the first is either denied or still pending, then the second application will be followed by visa stamping outside the United States. Okay? All right, *5 if you have a follow-up question on this. *5 if you have a follow-up question. Okay, so we have one question from Wisconsin. Okay, Wisconsin, go ahead please, Wisconsin.
Hey, hi Rajiv. That was my question. So I just want to confirm if I have to raise any of this case to premium, should I raise it to the premium, either the existing extension case or the new amendment file case?
See, the obvious answer is the previous case, because if the previous case is not decided and the second case is up for decision, previous case pending or denied has the same harm. Okay, but if the previous case is not approvable or approved, then it is for sure that you have to go outside the United States. Okay, and you won't be able to stay here to get a change of status. So you have to go outside USA for sure. So, I mean, I would want to, depending upon your personal mindset, I would probably want to get the case decided as quickly as possible. I would premium the first one, and if it gets decided in my favor, then I know I'm all set. If not, then I know I've got to go outside USA for visa stamping. Prepare for that. Okay?
Okay.
So I think premium the first case.
Okay. Thank you very much.
You're welcome. Good luck. Okay, next one is a question on H4EAD from Sunny D. I'm on H1B, I-140 approved. Wife is on H1B, I-140 approved. H4EAD applied for wife. EAD change of status requested as of May 1st of this year, not approved yet. Recently, DHS made an announcement that they are going to do away with H4-based EAD. Yes. So my application includes H4 plus a change of status to EAD. On approval of H4 EAD, my status will automatically change from H1 to H4. Oh, I'm sorry. So it's you have applied for H4 EAD, okay, not your wife. All right, I stand corrected. So yeah, that is correct, that once your change of status is approved, you will then be on H4, not on H1. If DHS decides to do away with H4 EAD, will it become illegal for me to work for my current employer on H4 EAD status, even though they hold my current H1B? The answer is yes. Because if you have changed your status to H4 and you are working based upon an EAD, and the EAD is nullified by the government, staying in the USA is fine, but you won't be able to use that EAD to work. By the way, it is my personal guess that they won't just dead stop the EADs, they'll give you some grace period. I don't know how much that grace period will be. In that period, you can apply for H1. So let's keep going. So yeah, you will not be able to work without getting back onto H1 once the EAD is nullified. Once H4 EAD is approved and I want to revert back to H1, can it be done within USA? Yes, you should be able to do it within the United States. I don't see any issue with that. If DHS does not do away with the H4 EAD rule, will it be easy to switch back to H4 EAD from H1B in the future? Yeah, changing from H4 to H1, H1 to H4, and of course the corresponding EAD is just an I-539 along with an I-765, as you know. So it's not really complicated, nor is it legally impermissible. You can go from one to the other. *5 if you have a follow-up question. *5. Okay. So this one is from my neighborhood, Washington, D.C. Washington, D.C., go ahead, please.
Hi, Rajiv. Yeah, that was my question.
Ji.
So like I mentioned, I already applied for EAD back in November, and at that time, DHS did not mention anything about going away with this rule, and we came to know about this in December. So my approach was either to cancel the application altogether because I'm already on H1B, stay with my employer on H1B, or so I decided not to cancel my application, go with it no matter what happens with the rule. So first option is, once that becomes active, of course my status will all become from H1 to EAD. And let's say I don't feel comfortable with EAD status in US because of the rules going on. I do want to change it back to H1. In that case, you mentioned that it can be done within the US as well. My thought was go to like Canada, like Toronto, and come back to US on H1B stamp, since I already have an H1B stamp on my passport till next year.
Let me think about this for a moment, okay? So you've got a valid H1B approval. You have converted to H4. Your employer never revoked your H1. Can you just go outside USA and come back? I have to think it through, but theoretically it sounds okay. However, since I haven't taken the time to spend half an hour, 45 minutes thinking about the various angles involved in this, I wouldn't be able to tell you this is a good course to follow. That's something your lawyers can help you with. But at least tentatively, that plan appears to be workable.
Okay. So, but then you mentioned if I don't have to go out of the US, which is good, it can be done within US as well. In that case, does my employer have to do anything, or it can be done by me as well?
If you want to do it within the United States, you would have to apply for change of status back to H1. That change of status application is like filing an H1 all over again. It has the same paperwork, employer has to file it, and it could raise the same difficulties as you have or had when you file your H1 as in the beginning. So they can question specialty occupation, end client letter, are you one of the unacceptable titles? So they get into all those things, and all of those things can be brought up again when you do a change.
Even though if I work with my same employer, nothing has changed. I work with the same employer who has my H1B.
Doesn't matter. It can still be
okay. So it's like H1B transfer, even though I have H1B from my current employer.
H1B transfer, H1B extension, and new H1B, it's pretty much the same paperwork.
Okay, so it's not so. I have to inform my employer if I have to change my status to EAD and I want to convert back into H1. I have to inform my about it, right?
They have to do the paperwork, yeah, for sure.
Oh, okay. But if I go out of the country, because I think my understanding from you, you're not sure about that.
I haven't, like I said, I haven't given it enough thought, but tentatively it does seem possible. It does seem possible. Why not?
But in that case, I don't need to. My employer does not need to file the paperwork again, right?
No, they do not.
Oh, okay. Okay, got it. And okay, I think that's it. Yeah, that was my question. Thank you.
Good luck, sir. Okay. Let's go on to the next question. This one is from G. Aurora. I got my green card using cross chargeability. After 18 months of marriage, my first wife filed a divorce. We got divorced. I remarried 3 months later. Then second wife filed divorce in 2016, around 2 years after marriage. Then a year after divorce, your wife moved in with you again. You're still divorced, but you're living together, I guess. So if I plan to apply for US citizenship this month, I meet all the other criteria, taxes, etc. Are these failed marriages going to be a problem? I don't think so. As long as the marriages were entered into good faith, I don't see any problem. If things go the way they are today and my ex-wife agrees to remarry and I file her I-130, do you foresee any problems with that? Gagan, I really don't. Because the bottom line is, as long as the marriage is entered into in good faith, I don't see why not. I actually have a friend with exactly the same fact pattern as you. He is already a US citizen, but he went through the same thing. He got divorced from his first wife, got divorced from his second wife, and then they started living together again. So that's not, I mean, it's not impossible. And as long as it is in good faith and honest, I don't see why you can't file for her green card. I think you can. *5 if you have a follow-up question. *5 if you have a follow-up question. Okay. This one is also from my neighborhood. Washington, D.C. Go ahead, please. Washington, D.C.
Hello, Rajiv. This is Gagan. So, like for my first marriage, since it was cross chargeability and we got divorced so soon, should I prepare for any bona fide marriage proof when I go to the...
You were married to her for 18 months, right?
Yeah.
And you live together, right?
Yes, we live together, and then we lived together, filed taxes together,
Right.
we had a joint venture, etc., etc.
As long as it was an honest marriage, no problem at all.
Yes. Okay, but the thing is, like, when I go for the interview, should I take all the documentation? Should I start preparing for it, or should I just worry about it?
You should bring whatever the interview notice asks you to bring. And if the government wants more information from you, they can send you an RFE for it.
Okay.
Okay. Good luck, sir.
Okay.
Yeah.
Thank you.
Bye-bye. Okay, let's go on to... This is from April Wilson. Worked with green card sponsoring employer, which is a consulting company, after EB2 green card. At the time of naturalization, what type of documents are enough to show the proof that I have worked for them after green card approval? Well, I'm not sure that you are required to prove that, but normally things like your old W-2s should be sufficient. You have the W-2 pay stubs with the salary promised at the time of the green card, social security payments made by the employer. Oh yeah. All these documents are more than enough, April. I think you should be fine. *5 if you have a follow-up question. *5. It's not important, I think, to have documents like client letters, contracts. I recently just did a consultation on a case which we are going to take over and represent the individual. His company had committed fraud and they were indicted for fraud. He was not involved, of course. He got his green card before the fraud charges occurred. But when time came for his naturalization, they are asking him for job descriptions for all the times that he was working with that company, which was 4 or 5 years. So of course he doesn't remember all that. Some things are impossible to comply with. So we're not going to comply with those, and we're going to explain to them, look, nobody can keep track of what you did 3 years or 4 years or 5 years ago. So, and you make your best faith efforts, good faith efforts. And in your case, I think you have more than enough information and documentation. So you should be okay. Star 5 if you have a follow-up question. Star 5. Star 5. Okay. Next question is from Animesh. My I-140 was approved in EB3 working as an architect in Ohio. Now I'm getting an offer as a technical project manager from another company. Can I convert this into EB1 category? Well, I think you need to reassess that. There are two kinds of EB1s. EB1C is for international managers. That is, if you have worked for a branch of this company or subsidiary or a sister company for 1 year outside the United States. Only then you can be transferred into a green card or an L1A. L1A and EB1C. So that category is called EB1, EB1C. There's another category called EB1A, where if you can prove that you're one of the top guys nationally in your profession, you should be given a green card. So if you're thinking EB1C, just because you have a managerial job does not get you an EB1C. You have to have worked outside the United States for this company. Okay. Star 5 if you have a follow-up question. Star 5. Okay. Son123 got my green card as a derivative to EB2 in Jan 2016. Married for 15 months. Husband filed for divorce. We got divorced in October 2016. I remarried 5 months after the divorce. I plan to file I-130 for my current husband. Is there any chance they'll ask to prove my previous marriage was bona fide? Well, there is some requirement. If you got a green card through a marriage, then you have to have a certain amount of waiting period before you apply for your spouse. But you didn't get your green card through marriage. You got it through derivative status. So I don't think that's a problem. Normally, they should not create an issue about it. But if they do, even though you had a short marriage, you have joint taxes and a few pictures. Yeah, I think get yourself a lawyer if you got into any kind of trouble. You can submit affidavits of friends and neighbors attesting to the fact that you live together like a husband and wife. So I don't think that's going to be a solid impediment to your second green card application. Star 5 if you have a follow-up question. Star 5. Okay. Suren.yellow got my H1B approval from employer A 2016 to 2019. Changed employer in 2017. Got approved till September 2018. I didn't apply for H4 for my wife. H4 is still good till 2019. January the first employer revoked my H1B. Is my wife out of status now? I do not know. This is a very odd set of circumstances. All I can do is give you my best guess. My best guess is that her status is coextensive to your status now. Previously it was coextensive to 2019. Now it is coextensive to September 2018. That would be my best guess. Even though you didn't apply for her definitively, I believe that she's still good till September 2018. I don't believe in hypothetical exercises. Why not just let's see, her status is good till September 2018. So I would say 6 months ahead of time. In 6 months ahead will be what, March? Yeah, March. In March, you can apply for her H4 extension. I personally think she's okay now till September 2018, but you can apply for her extension in March. Okay. Again, please have your lawyers look at this situation a little carefully because you have a very unique fact pattern. But my guess is that she's okay till September 2018. Star 5 if you have a follow-up question. Star 5. Okay. Let's see. This one is from New York. Okay, New York, go ahead, please.
Yeah, hi Rajiv, this is Suren.
Yes,
So that's if I apply like 3 months before in June, along with my H1B premium, the H4 status, that would be fine, right? So you are saying our status is still valid to September 2010.
I think so, Suren. I think so. But, somebody should take a look at this case, maybe even discuss it with the USCIS, just to make sure that my understanding is correct. My understanding is she's good till September 2018, coextensive with your current H1 extension, even though the old H1 has been revoked based upon which her H4 was granted. So I think she's okay.
Okay, because I checked on the USCIS website with the case number, it didn't say anything like it's got revoked.
Don't depend upon that.
Oh,
All right.
so I can file the change of status, along with my extension when I file again. Okay.
Good luck, sir.
Thank you, Rajiv.
You're welcome. Okay. Then we go on to this is from Quain and J. My petition for green card was approved 31st December 2011. Eligible for citizenship since 2016. Oh yeah, so in your case there is a pending 498 charge criminal complaint filed by ex-wife. Should I file for citizenship or wait for dismissal in India? I just filed a response to this situation. We had a consultation a few weeks ago. Somebody who had a 498 complaint pending, and when he applied for N400, he got an RFE from the government saying, well, you got this complaint pending. It doesn't look like you're eligible for naturalization. And then what I did was, and I'm trying to remember, no, this was more than 2 weeks ago. This was 3 or 4 months ago. We took the case, and I remember preparing a response or guiding the response, which basically said, look, first of all, 498s have been so badly misused that they have become objectionable even by Indian standards, and there were some studies and reports and government and media reports on that. Second, that case was filed against parents as well as this individual. The case against parents was dismissed on the same evidence. The only reason the case against the individual went on forward is because he couldn't go back to attend the hearing. So I am hoping that they're going to back off that and just grant the citizenship, because, and the last argument was a policy argument that the US government shouldn't be supporting policies of foreign countries which are contrary to the themes of morality or fair play we have in the United States. So to answer your question briefly, if you have a 498 complaint pending, what I have seen is they'll raise an issue about it. Will you be able to answer to it? I don't know rest of the facts of your case. Maybe. Will you be able to win? I do not know the answer to that question. So the way I look at it, if you file the N400 now and it is denied eventually, the only thing you lose is money, right? So you could certainly try. Is this going to be a problem for my green card renewal? I don't think so. I really don't. Yeah, I think I would apply for the N400, making a judgment call on all these issues. This is not mathematics. All we can do is take a reasonable estimate of the situation, and that's what I have done. I think filing for naturalization is okay in your case. *5 if you have a follow-up question. Okay, there is a follow-up question. Go ahead, please. This is
hi, Rajiv.
yeah, go ahead.
Yeah, my name is Amit.
Yes, sir.
Okay, the complaint that she has filed, it is based on charges that happened in USA, which she filed for in USA. They have been dismissed.
Hang on. That is a very interesting point. Because if these charges were dismissed in the United States, I think you have a very good argument that they should not, just because somebody has complained in a different country, they should not be able to withhold or hold up or block your application. So yeah, I agree with you.
But they drummed up the charges.
I'm kind of preempting your question. I think I agree with you. I think I agree with you. File the N400, and if they create a problem, then you do have these good arguments. Okay.
Okay.
Good luck.
Well, then if I get a query, then I'll come to you.
Of course, I hope you don't come, and I hope I don't talk to you again and it just gets resolved. But yeah, if it does become a problem, you call us, we'll take care of it, okay?
Okay, but and one last question. If for any reason they deny my citizenship, can they deny my current GC or future renewal?
No, I don't think so, because it is not an American conviction in anything. I think, look, anything is possible. Government can come after you for foreign convictions as well. But once you have your green card and it has been approved for 5 years, it is not as easy as just sending you a notice. They have to take you to immigration court where you get to make your complete case. Okay. So personally, I think that's a remote possibility. I would be willing to take that chance if I were you. And I'm pretty conservative. I don't like taking chances. But this is the kind of chance that I would want to take. Okay.
Okay, that really helps. Thanks a lot.
Good luck, sir. Always a pleasure to help, guys. Let's see. Next one is Abhishek Kumar. Okay. Abhishek Kumar. Families in the US as follows. Currently working on L1B. Green card is under process. Wife is on F1. Daughter is on F2 in class 12. So she's been selected for undergrad computer engineering. Session starts from September 2018. We want to convert to F1. She'll travel to India for visa stamping. So there's an intent to stay in USA. Yeah, interestingly, I just did a consultation on this this week. I want to say it was day before yesterday. Somebody with exactly the same situation. And they had exactly the same question. That if my daughter goes to India or to Canada or any other country and she applies for a student visa, isn't that going to be damn difficult because her whole family lives in USA? She has been living in USA for the last 6 or 7 or 8 years. She went to school here, high school here, grade school here, all these middle school, everything she went here. So my answer to that was, yeah, as a technical matter, they can definitely at the consulate take an objection and say you don't have any intention to return. But as a practical matter, if somebody has obeyed all the laws and they're in this unique situation, frankly, I know many students who've gotten their student visa. And of course, you can also apply for a change of status. Instead of going to India for a visa stamping, you can apply for her to change status from F2 to F1 within the United States. And it is my belief that while the application is pending, if the school starts, she can start school even with a pending F1 application. *5 if you have a follow-up question on this. *5. Okay. This one is from our neighborhood in Virginia. Go ahead, Virginia.
Hey Rajiv, this is Abhishek.
Yes, sir, Abhishek. Go ahead.
So Rajiv, the question is that we understand that the visa can be changed from F2 to F1 within US, but in some of the colleges they tell you to go to study abroad
and in that case, she will need a visa.
Yeah, sure. But she can get a visa later also. She can get a change of status now and get a visa later. But that's not something. It's really not predictable. She could have the same problems here too. So I am not sure I can give you an answer that is based upon good legal principles. This is a judgment call and a little bit of chance taking. I really cannot tell you what is better than something else. So just choose your poison and take it. Personally, if it were my daughter or my sister or my friend, I'd probably send them to Canada for visa stamping.
Okay. And a follow-up question on that, Rajiv. Since I'm a L1 and then I'm waiting for I-140, the company is also filing for H1. So if I get her on H4, I think, will she be eligible for the OPT once she completes the college?
No. You have to have been on F1 status for 2 full semesters. I think it's 9 months before you can be eligible for OPT.
Oh, okay. All right. So yeah, so
H4, F2, L2 will not be eligible for
OPT.
Yeah.
Okay. Yeah, thank you so much, Rajiv, for your advice.
Always a pleasure. Good luck.
Thank you.
You're welcome. Bye-bye. Okay, so this one from Ram says Associate Project Manager in India from 2013 to 2015. Moved to USA with the same company as a principal consultant. Got promoted in 2016 as a solutions manager. Can I do EB1C category? Yes, you can, as long as, see, you entered in 2015. So within 3 years of that, you were a project manager. And you are now applying. I think you should be able to qualify for an EB1C category, but a lot depends upon both the job of project manager and solution manager being managerial. So if they are managerial, EB1C is a possibility. *5 if you have a follow-up question. *5. Okay. Hi Sarji, Nick, H1B, relative has a company. Can I be an authorized signer on a business account for the company? And I'm very reluctant to advise that because that seems to indicate a little bit more control than a normal employee. If I were you, I wouldn't do it until you file an H1 next time. In that, you can add a line to the job duties, may have to act as a signatory on bank accounts as needed. Discuss it with your lawyers. So I like to reveal these things to the government. So if they want to raise any questions, let them raise them before they approve the H1. So I probably wouldn't take that risk without an amendment. *5 if you have a follow-up question on that. *5. Okay. Next question is from TPD. I'm currently in an AOS pending 45 status in EB3 in India. I have an approved I-140. I've been on EAD. I changed employer in 2013. Filed AC-21 portability, RFE. Got married in the meantime. You have 3 questions. I can't help you fill forms. So, no, I can't help you fill forms. I can't help you there. I'm planning to provide spouse marriage details in this form. This is the first time I'm including marriage information. Okay, so I personally think it's a good idea to submit marriage information. How could it hurt? Okay, it's not required, but you could submit it anyway, because this also puts on the record the fact that you're going to do a following to join. I don't see any risk in filing a following to join. If your priority date is current, there is no following to join needed. Just file the 485 if your spouse is here. If your spouse is in India, only then you have to file, or outside the USA, only then you have to file a following to join. Star 5 if you have a follow-up question. Star 5. Oh, good. You're here. I can ask you that. Hi, California. Is your spouse in USA or in India?
India.
Then you have to do a following to join. Following to join is kind of weird. Okay. So the way it is that there has been an evolution in different thought processes in the filing of the following to join Form I-824. It used to be that we could file it any time and the government would approve and send the file to NVC when your case gets processed. Now, from what I understand, first of all, they won't even accept a following to join 824 until the dates are current. And this is something I'm not clear about, but they may not even accept it until your case is approved. So until your 485 is approved, they may not accept an I-824, but what do you have to lose? Just money, right? So you can try it, but they may bounce it back and say, wait till your 485 is approved. Go ahead with your questions if you have any.
No, that was it. You answered it.
Good luck.
Thank you.
All right, guys. Anybody has any questions, raise your hands. Star 5. Anybody has any questions? 1, 2 questions. Okay, good. Well, no more after that. Please raise your hand now if you have any questions. 3. Okay. So these are the 3 that we will do. One is from Illinois, another one is from Washington State, and another one is from New Jersey. Okay. Starting 1, which one is this? Let's see. This one is...
Hello, Rajiv.
Yeah, Illinois. Go ahead, please, sir.
Yes, I'm the one with the Indian passport holder but born in a North African country.
Oh, yeah, I remember your case.
Yes. I think my ultimate question was, if the I-140 and 485 are filed, do I need to stay with the same employer or can I do it by myself?
Let me pull your question out. I'm a little confused what you're asking me. Give me 1 second, okay?
Sure.
Do you remember your question number? Which question number you were?
It was the second question.
Okay, good.
Abhishek Verma.
Ji, Abhishek ji, 1 second. Oh yeah, so you had the wrong date of birth entered.
No, that wasn't me.
No? That's Madhu.
No, sir. Mine.
Yeah, that's number 2. Question number 2 is wrong date of birth. Okay. Wrong place of birth. Question number...
Oh, I'm sorry. It must be question 3 then.
Okay, 1 second. Oh, yeah. You are question number 3. I see it. So, did my undergrad work, etc., etc. I'm from Libya. When my 9089 comes, can I file for my I-140, 485 in premium processing? If I file I-140, can I leave the country? Okay, now your question is, if I file the I-140, 485, do I have to stay with this employer? Is that what you said?
Yes, or can I do it on my own?
Well, 485 is your application, but I-140 is the employer's application. So you can't do it on your own. And you also cannot leave the employer until your I-140 is approved and 485 has been pending 180 days.
Oh, I see.
Okay.
Okay, I understand. That's all I had. Thank you so much.
You're welcome. Good luck. Okay, let me go to... Oh, so we have only one more question. This one is from New Jersey. Okay, New Jersey, go ahead. Last question of the day. New Jersey, go ahead. Yeah, hello. Go ahead, please. New Jersey. Hello. Okay, for some reason, I guess we are disconnected.
Can you hear me now?
Yes, I can. Go ahead, please.
Okay. Hello, Rajiv.
Hello.
So, I had a question which you may have answered before. At the risk of repeating yourself, these were cases where people
from IBM or Cisco, they're sending their employees back to India if their amendments were denied. We don't know why they send them back, but the underlying question over here was their original petition, whether it was a transfer or an extension, that would still be valid. So those people could still essentially go back and work at whatever locations were mentioned in their original petition.
That is correct. In fact, this is interesting. What USCIS has said in one of the meetings with American Immigration Lawyers Association, and I think they also mentioned that in one of their memos. So if you have filed for an amendment and you started doing the amendment job, but the amendment was denied, if the old job under the already approved H-1 is still valid and that case has not been withdrawn, which it shouldn't be, it's the same employer, you can go right back and start working there. And the answer to that question is yes, you should be able to resume the old job.
Okay, thank you so much.
You're welcome. Good luck.
Thank you.
Okay, I think you got disconnected, Washington State. So let's get you attended to. So Washington, go ahead, please. This is the last call of the day. Washington.
Good afternoon, Rajiv sir. I have a question regarding GC process.
Yes.
My previous employer, I had I-140 approved with 2011 priority date.
Okay.
And with my new employer, I started my GC under EB2. The previous one was EB3.
Mm-hmm.
And I would like to know if the priority date becomes current for EB3 within a certain amount of time before my new employer comes to the I-140 stage.
Mm-hmm.
Will I lose the priority date?
No. So let's say that this month your EB3 priority date becomes current. And
Mm-hmm.
next month it stops being current. You don't lose your priority date. Priority date is yours to keep under the new law, under the current law forever. So even theoretically, even after 20 years, you could still use that EB3 priority date.
Oh, great. So even though the categories that we are applying is different and
No worries.
I did not come to...
Yeah, no problem at all.
Okay.
This is written in 8 CFR section 204. So under the Code of Federal Regulations section 204, it's clearly said that priority dates can be ported across categories, and we also know that once an I-140 is approved, that priority date is yours forever. Priority dates, movements can come and go. We don't really care.
Even when I'm not reached the I-140 stage in my new EB2,
it doesn't matter.
Right?
It doesn't.
Even
matter. It doesn't
okay.
matter. It doesn't matter. Let's give you an example. Let's say your EB3 I-140 got approved. Then you moved to India for 10 years. And after 10 years, you decided to start another green card in USA. You'll still carry the priority date from the old case.
Okay. That's great. Thank you. Thank you very much.
You're welcome. Good luck.
Yeah. Thank you. Bye.
Bye-bye. So, folks, I will see you again in 2 weeks. I always enjoy talking with you, and thank you for this opportunity to talk with all of you. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time, every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.